Welcome once again with another GST topics on customs and GST advisory channel of customsgst.com. If you intend to understand this topic, please see the complete video and comment if you have contradictory opinion. One of the biggest misconceptions in GST litigation is that once the department issues a show cause notice under Section 74 of CGST Act, it can investigate whether fraud exists during adjudication. Legally, that approach is flawed. Before invoking Section 74, the department must first establish that the statutory conditions for exercising Section 74 jurisdiction actually exist. This introduces one of the oldest principles of administrative law, jurisdictional facts versus adjudicatory facts. Understanding this distinction can determine whether an entire Section 74 proceeding survives or collapses. Every statutory power begins with jurisdiction. No statutory authority possesses unlimited power. Every authority derives its power from legislation. Before exercising any power, the authority must satisfy the legal conditions prescribed by Parliament in relevant section. These conditions are known as jurisdictional facts. Without them, the authority has no legal power to proceed. What is a jurisdictional fact? A jurisdictional fact is a foundational fact that must exist before the statutory power itself becomes available. If this foundational fact is absent, every subsequent proceeding becomes legally unsustainable. The authority cannot create jurisdiction merely by making an allegation. Jurisdiction depends upon objective existence of statutory conditions. What are adjudicatory facts? One of the most important distinctions in administrative law is the distinction between jurisdictional facts and adjudicatory facts. Once the jurisdictional facts exist, the statutory authority acquires the legal power to initiate proceedings. However, obtaining jurisdiction does not mean that the dispute has already been decided. The adjudication only begins thereafter. Jurisdiction opens the door. Adjudication decides the dispute. The existence of jurisdiction merely authorizes the proper officer to conduct an inquiry. The authority must then examine the evidence, hear both parties, consider the law, and determine the disputed issues. These disputed issues are known as adjudicatory facts. Unlike jurisdictional facts, adjudicatory facts do not confer power upon the authority. Instead, they determine whether the demand is legally sustainable and if so, to what extent. What questions are decided during adjudication? During adjudication, the proper officer decides questions such as, number 1 is tax liability, whether any tax is actually payable, whether there has been short payment or non-payment, whether the transaction attracts GST, whether any exemption applies. This is not a jurisdictional issue. It is the very subject matter of adjudication. Number 2 is classification dispute. The authority determines under which tariff heading or sack the goods or services fall. Different classifications often attract different tax rates. This determination requires interpretation of the tariff and evidence. Therefore, it is an adjudicatory fact. The issue of valuation of goods and services is decided during adjudication. The officer examines what is the correct transaction value, whether any amount has to be included or excluded, whether rule-based valuation applies, whether related party valuation provisions apply. These questions affect the amount of tax. They do not affect jurisdiction. The authority also determines whether the assessee satisfies the conditions of a notification, whether exemption is available, whether conditions have been violated. Again, these issues arise only after proceedings have validly commenced. Even if liability exists, the officer must determine the taxable turnover, applicable tax rate, tax amount, deductions, admissible credits, and the final demand. This exercise constitutes adjudication. The proper officer must determine whether interest is payable, from which date, at what rate, for what period. These questions depend upon findings recorded during adjudication. Penalty never follows automatically. The authority must determine whether statutory conditions are fulfilled, whether penalty provisions apply, the applicable provision, and the quantum of penalty. This is a classic adjudicatory exercise. Adjudicatory facts are decided after evidence. Unlike jurisdictional facts, adjudicatory facts are decided after issuance of show cause notice, filing of reply, production of documents, cross-examination where permissible, personal hearing, appreciation of evidence, interpretation of law, and reasoned findings. Only after this process can the proper adjudicating officer determine tax liability. Section 74 is not the normal assessment provision, it is an exceptional provision. It permits longer limitation, it permits higher penalty. It carries serious civil consequences, therefore Parliament restricted its use. Section 74 applies only where tax has not been paid or has been short paid by reason of fraud, willful misstatement, suppression of facts, or similar intentional misconduct. Those are not ordinary allegations. They are jurisdictional conditions. Why this distinction matters: suppose an officer writes, "I believe suppression exists." Is jurisdiction automatically established? The answer is no. Otherwise, every Section 73 case could simply become a Section 74 case by adding one sentence. That would destroy the legislative distinction between Sections 73 and 74. Parliament never intended that result. Mere allegations cannot create jurisdiction. An allegation is not evidence. Suspicion is not proof. Inference is not a jurisdictional fact. The department must possess objective material showing that the ingredients of Section 74 are attracted before invoking that provision. Jurisdiction cannot be assumed merely because fraud is alleged. What should exist before invoking Section 74? Before issuing the show cause notice, the proper officer should possess material indicating deliberate concealment, intentional false declaration, conscious misstatement, or deliberate suppression of material facts. If such objective material is absent, the very assumption of jurisdiction becomes vulnerable. Can adjudication cure lack of jurisdiction? The answer is absolutely negative. This is one of the most important principles in public law. Jurisdiction must exist at the inception. A proceeding that begins without jurisdiction cannot be validated merely because evidence is collected later. Subsequent investigation cannot retrospectively create jurisdiction. The legality of the notice must be judged on the material available when it was issued. Let us consider a practical illustration. Suppose GSTR-1 differs from GSTR-3B. The officer immediately issues notice under Section 74. Question: does a mismatch itself establish fraud? Certainly not. It may justify inquiry, it may justify verification. But it does not automatically establish suppression. Therefore, unless additional material exists showing intentional evasion, Section 74 jurisdiction itself becomes questionable. Why courts insist on strict compliance of jurisdictional conditions? Section 74 extends limitation, imposes severe penalty, carries allegations of fraud. A provision having such serious consequences cannot be invoked casually. The department must strictly satisfy every jurisdictional condition. Otherwise, the extraordinary power becomes arbitrary. Burden to satisfy Section 74 condition is on department. The department cannot simply state, fraud will be determined during adjudication. The answer is no. Fraud is itself the reason why Section 74 is invoked. Therefore, there must already exist objective material justifying invocation of Section 74. Only then can adjudication proceed. The controversy can be summarized in one sentence: jurisdictional facts confer power. Adjudicatory facts determine liability. If jurisdictional facts do not exist, the authority never lawfully acquires power to invoke Section 74. Everything that follows stands on a defective foundation. That is why taxpayers must always examine not only the allegations, but also whether the statutory conditions for exercising Section 74 jurisdiction actually existed on the date the show cause notice was issued. Let us now conclude this topic. Understanding this distinction is essential for every GST professional. Many taxpayers focus only on defending the tax demand. The first question should instead be, did the department possess jurisdiction to invoke Section 74 at all? If the answer is no, the legality of the entire proceeding may itself be open to challenge. If you found this legal analysis useful, please like this video, subscribe to the channel, press the bell icon, and visit us at customsgst.com for more in-depth discussions on GST, customs, and indirect tax litigation. Thank you for watching.